Some of you are asking, well, what do you mean that district judges should not have the authority to imprint upon the entirety of the United States of America? And I want to go there in a moment. And you're welcome to call us if you've got any concerns or questions. Also, I heard that there was some sort of an explosion earlier today near Hendersonville, and we're not getting any reports on that. I looked into it. I had a super texter ask me about it. So, you hear anything about a few hours ago that something rocked the Winders, Winders, Winders. Well, if your windows were rocked, that must be pretty powerful. I've not heard anything about that, so just relating that to you. So Article 3, Section 1 of the Constitution, and I pulled it up because I want to read it properly, has this to say about lower courts. Section 1, the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. The judges, both of the Supreme and inferior courts, shall hold their offices during good behavior and shall at stated times receive for their services a compensation which shall not be diminished during their continuance in office. Section 2. The judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States and treaties made or which shall be made under their authority. To all cases affecting ambassadors, other public ministers, and consuls. To all cases of admiralty and maritime jurisdiction, to controversies to which the United States shall be a party, to controversies between two or more states, between a state and citizen of another state, between citizens of different states, between citizens of the same state claiming lands under grants of different states, and between a state or citizens thereof and foreign states, citizens or subjects. I could go on, but I don't want to belabor the point. The point is this. The Congress set up the lower courts as allowed by the Constitution, Article 3, Section 1. The Congress can clarify this. The courts, assuming that they have extended jurisdiction beyond their boundaries, is ridiculous. And it's ridiculous to automatically assume or suggest that that's what they have. Their boundaries are what they are. So if you are a district court bound by a district, then your rulings ought to be bound by said district, regardless of how it might manifest or affect itself otherwise. Now, the Supreme Court is different. And I don't pretend to be a constitutional scholar, but you know what? I didn't get off the garbage truck or the turnip truck yesterday either. The Supreme Court, when they make rulings affecting one local jurisdiction, it is assumed and it is a foregone expectation that those rulings will have impact and effect on every other jurisdiction impacted. So as a time saver, for example, and Jay St. Clair used this on Friday, and it's a good one. Do you know how many schools were directly impacted by Brown versus Board of Education? Anybody want to guess? One. Then why in the world do we all point to Brown versus Board of Education as the Supreme Court ruling that desegregated all of the school systems? Because in a de facto way it did. Because at that point, all of the other cases happening in all of the other jurisdictions, there were still plenty of cases that had to be adjudicated. But guess what? For those who wanted to desegregate schools in Tennessee or desegregate schools in Alabama or in, Minnesota, wherever it might have been, where there was segregation present, guess what those folks get to point to after 1954? Well, the Supreme Court kind of spoke on this, Your Honor, whoever Your Honor might be, and it was called Brown versus Board of Education. But from a direct impact status, it impacted one school. But it was expected that it would impact every other. I'll give you what was the gay marriage? Obergefell. I think it was Obergefell that the Supreme Court ruled on that a state did not have permission to make different rules and different sets of regulations regarding a state's recognition of marriage, depending on whether or not the couple in question was same-sex couple or a couple of heterosexual couple. Boy, it's almost quaint. That was back in the day when liberals could tell you that there were only two genders. Isn't that funny? Now there's like 160. But in that case, similarly, because it was the United States Supreme Court and because the United States Supreme Court is treated differently than other local courts, there's no opportunity to overrule except for a new court to take up a case that would eventually overturn the precedent set in the previous case. See Dobbs v. Jackson, which set aside Roe v. Wade after 50 years. But district courts do not enjoy the same authority and never have. And rightly so, the Trump administration is challenging this concept that just because a district court might have jurisdiction, this goober head in D.C. might have jurisdiction in D.C. And yes, it is a legal matter that a court can, in its own jurisdiction, restrict movement from the executive branch or restrict action on the part of the executive branch until review is had. They can order a stay in their jurisdiction. But there is nothing in the language of the Constitution of the United States and nothing that I can find in the language anywhere written by Congress that extends that jurisdiction beyond their geographical boundary. In other words, when a judge in San Francisco, as a judge did last week, orders that all these probationary officers, or probationary employees, I should say, not officers, all of these are remember last week when a judge in San Francisco said, all of you probationary employees that have been fired by the executive branch of government in the Department of Labor or this department or that department, y'all can go back to work because they can't fire you until I say so. That's just garbage. Maybe one could argue that anyone impacted in his geographical boundary could go back to work. But how in the hell does a San Francisco judge have any say over what happens in Virginia? And don't tell me because he's a federal judge on the federal bench. He has a district court that has specific geographical boundaries defined under law. So one of two things have to happen. Per the Constitution of the United States. Either the Supreme Court has to clarify this, or the Congress needs to clarify it. And I think the Congress would do well to pass a law saying, look, obviously, district judges have authority within their geographical boundaries. We didn't think we needed to say this, but let's go ahead and say the unspoken out loud. They don't extend beyond their geographical boundaries in district courts. That is what the appellate process is for. You bring it up to the appellate courts, which have broader and wider boundaries up until the time that you get to the United States Supreme Court, which clearly interprets the law and interprets the Constitution for the entirety of the United States of America. Does that make sense to everyone? Why you don't want some whack job San Francisco judge being able to stymie and gum up the works for everyone across the United States of America? How that might be problematic? How that might be used against the American people in a negative way? I hope it does.